This is a lecture on substantial performance. Now, step one is to place substantial performance in its proper place in the law of contracts. You can see that on this board. The law of contracts is organized in this way. We're all very familiar with this by now. Contracts are formed and all the problems that go with formation. We interpret the terms of the contract. This is where we have issues such as ambiguity, parole evidence rule, mistake. People change their contracts, they change the terms, they change the people. But after they have formed the contract, gotten the terms clear, and made whatever changes they've made, then comes the question of, was there a breach of contract? And of course, on the bar exam, there'll always be a breach of contract, or at least an argument for a breach, because that's what the issues are about. Breach of contract is defined as the non-performance of a contract duty which has become absolute. The non-performance of a contract duty which has become absolute. So the question becomes, when has a contract duty become absolute? And the answer is that the contract duty is absolute when these requirements are satisfied. All conditions precedent to my duty to perform. By the way, now my duty, the breach of contract is non-performance of a contract duty which has become absolute, and the contract duty comes from the promises which were made when we formed the contract. I will do X for you and you're going to do Y for me. That's my promise. And when does the duty to perform that promise become absolute? And that's what this is about here. All conditions precedent to my duty to perform have occurred or been excused. I'm supposed to paint your house following the first 3 dry days in September. There haven't been 3 dry days in September. Condition precedent to my duty to perform has not yet occurred. Time for performance has arrived, except for anticipatory repudiation and prospective inability to perform. Those are exceptions where you don't have to wait for time for performance to arrive. And finally, the duty has not been charged. All conditions have occurred or been excused. Time for performance has arrived. Duty has not been discharged. And we discharge duties through the usual basis. The duty has become impossible, accord and satisfaction. The duty has been performed already, frustration of purpose, all that stuff here. So, getting back to here, duty is absolute when all conditions have occurred, have been excused, and it's excuse of conditions that we're focusing on. There's an entire lecture on this whole area of conditions, but the lecture that we're dealing with today, or the subject we're dealing with today, is substantial performance. In other words, when can you excuse a condition by substantial performance? And that's where we are. Now, for those purposes, let's have a convenient hypothetical, and here it is. You are a contractor, build a contract, and I own a parcel of land, and this parcel of land has a beautiful view of the valley, and I want to build an apartment building right here, and you and I have a contract where you're going to build the apartment building for me. And the contract provides that you will build a building according to the specifications which I have here, and I will pay you upon the occurrence of the event being that you present me with a completed apartment building according to these specs. Once again, the two promises are, you promise to build the apartment building, and now my promise is that I will pay you $1 million when you present me with a completed apartment building. So there's an event. I speak much better to speak of them as events than conditions. There's an event which must occur, and namely, you're present me with a completed building, and on the occurrence of that event, my duty to pay you the $1 million becomes absolute. And that's the nature of our contract. Now, please notice in this contract that you are promising to complete this building. But if you don't complete the building, I can sue for breach of that promise. But it is the presenting me with the completed building according to specs that is the event which must occur in order for my duty to perform to you to become absolute. Now, step one, of course, is that that's kind of a different kind of agreement. And society doesn't have to enforce that if they don't want to. Remember that just because I make an agreement with you, society doesn't have to come in and enforce that agreement. If we agree to go movies, they're not going to enforce that agreement. If I make an agreement with you and it's a product of fraud, duress, mistake, lack of capacity. I make an agreement with a 3-year-old kid. Society doesn't have to come in and enforce every agreement that I make. And it's likewise with these cases where there is an event which must occur before I have a duty to pay you. So you and I agree that when the event occurs, I have a duty to pay. Is society willing to enforce that kind of an arrangement? The answer is yes. The society has decided they want to do that because we can make some more sophisticated arrangements. So, but just like society doesn't have to enforce every agreement that we make, when the deal is that I'm going to pay you when an event occurs, society is going to take a look at those events which have to occur. And they're going to say, well, now, wait a minute. When I say I will pay you on the occurrence of certain event, the event can be absolutely anything at all in the world. And you can see how that can kind of get out of hand. I will pay you, I will buy your home from you for $100,000 if Joe assassinates the president of Jamaica country on January the 5th. Well, society isn't going to enforce that. Okay? And so the events which we describe, which must occur before my duty to pay you becomes absolute, society is going to look at those events and they got something to say about them. And that's what this lecture is about. It's about those events which must occur and what has society got to say about it. Now, the lecture on conditions did a whole lecture about that, about things that can happen to those events. The events may be impossible, the events may be waived, etc. And now we're talking about where the event did not occur, but it substantially occurred. And then what are the consequences of that? So back to my apartment building now. You're going to build the apartment building for me, and I'm going to pay you the $1 million when the event occurs that you present me with the apartment building. If you don't build the apartment building, I can sue for non-performance of that promise, but to build the building. But I do not sue. I do not sue for the non-occurrence of the condition of the event. The event is you're supposed to present me with a finished apartment building. I don't sue for the non-occurrence of the event. I sue for the non-performance of your promise. Now, so you are to build a building for me. We have this contract, and you go to work and you bring in your bulldozers and you clear the land and you do all the stuff you're supposed to do, and you build a foundation for this apartment building. You build the exterior walls and you do the plumbing and all that kind of stuff, but you don't have a roof on the building yet. And you breach the contract before you put the roof on. Everything's done except the roof, and you breach the contract. Now, the exact way in which you breach is not important for our purposes now. Main thing is that you walked away from the job for some reason, and we've decided you breached. And you have spent, at this point, you've put $500,000, $500,000 into labor and materials into this building, and you breached. And so now you're in a position where, gee, you'd like to get your $500,000 back. After all, I've got a partly completed building on my land, and you spent $500,000 and you breached. You'd like to get your money back. And so what you can't sue me for breach of contract because you're the breaching party. So you have to sue quasi-contract to prevent my unjust enrichment. So you could sue quasi-contract and get your $500,000 on that basis. Now, that's okay, but when you think about it, you say, what you would really like to do, is that you would like to think of this in a different way. You like to think of this in terms of if suppose this building is all completed except the garage door isn't painted. Well, if it's all finished except the garage door isn't painted, what you do is you say, look, Emerson, I have substantially performed, or whatever that means. This certainly would qualify. We'll talk about exactly what that means in a few minutes. But you would say, hey, I have substantially performed, and that I should pay you the $1 million contract price minus what it costs to paint the door. And that's the way you'd want to look at it. And so the way you'd look at it is you'd say, look, you're going to make an argument that even though the roof isn't on the house yet, that you have substantially performed. Now, let's suppose that it costs exactly $250,000 to put the roof on this apartment building. And so in that case, if you have substantially performed, you are entitled to the contract price, the $1 million, minus the $250,000 that it would cost me to put the roof on. So I pay you $1 million minus the $250,000. And you would much prefer that, because that way you get $750,000 instead of $500,000. And so you're going to forfeit $250,000 if you can't establish that you have substantially performed. So you can see why you would much rather have substantially performed, because then you get the contract price minus the damages, whereas otherwise all you get is quasi-contract and you lose all your profit. Now, so the question then becomes, how do you decide whether or not what you have done amounts to substantial performance? And you say, well, let's see. We want to be fair. Now, I bargained with you to get my apartment building finished, and let's go back to the case where everything's done except the garage door is not painted. Well, in that case, surely you have substantially performed. But we need some factors or something to look at so we can figure it out in the hard cases, like where the roof is not on, and that's a bigger deal. Is there really substantial performance there or not? So we need some factors, and the factors that we look at to try to decide whether or not you have substantially performed, we'll look at it from my point of view, and then we'll look at it from your point of view, and we'll see what's fair. Because as a builder, you want that $250,000 profit. So you'd like to prove you have substantially performed. So what factors would you take into account in making that decision? Well, factor one, let's look at it from my point of view and your point of view. From my point of view, I got into this contract with you to get a certain benefit, something I wanted. It's the only reason I got into the contract. I want my apartment building finished. And so factor one would be, well, how much of the apartment building have I already received? Whatever I was bargaining for, how much of that benefit have I already received? And that's important in deciding whether or not I should pay the contract price or not, whether or not you have substantially performed. Second factor we look at is if you didn't quite do everything. You didn't paint the garage door, for example. If you didn't quite do everything, then can the discrepancy, the minor breach, obviously if you've only substantially performed, you have committed a minor breach. That's not a question. So if you only substantially performed, you've committed a minor breach. If I get damages for that minor breach, get money, will the money damages compensate me enough so I can get everything I wanted? If you didn't paint the garage door and you've committed a minor breach and I pay you the $1 million minus the cost of getting the garage door painted, I can get somebody to paint the garage door and I got everything I wanted. So the two factors in looking at it from my point of view are, number one, how much of the benefit of my bargain have I already gotten? And secondly, can I get the rest of mine by getting damages from you? Can what's missing be adequately compensated by damages? Now, some things can't be compensated by money so much. And if I can't get my whole benefit by getting what you've done plus money, then that doesn't look so good. Maybe you haven't substantially performed. But if I can compensate by money, then it looks like you have. So the two factors looking at it from my point of view, how much benefit have I gotten, and can I get the rest based by compensation by money? Secondly, let's look at it from your point of view. Okay, from your point of view, how much have you done? Because we're trying to be fair now. How much of this work have you actually done certainly is a factor. And you would say, gee, I brought my bulldozers out and I reshaped the surface of the land the way it's supposed to be, and I built the foundation, and I built all the exterior, and I put in the plumbing and the electrical. You've done a lot. You didn't have the roof on, but you've still done a lot. So another factor in deciding whether or not it's fair to find substantial performance is how much have you done. Next factor is how badly will you be hurt if we decide that this is a material breach as opposed to a minor breach. What is the hardship that you would suffer? Hardship is a key term. What is the hardship you would suffer if the court decides that this is a material versus a minor breach? Now, what would happen if the court says this is a material breach? You don't have the roof on the house now. You don't on the apartment building. If the court says that's a material breach, then all you're going to get is your $500,000 quasi-contract. But if the court says, nah, this is a minor breach, this is a non-material breach, you have substantially performed, then you're going to get the contract price, the $1 million minus the $250,000 it cost me to put the roof on. So you get $750,000 if you have substantially performed. You get $500,000 if you haven't. And so the hardship that you would suffer, you would forfeit $250,000. You forfeit all your, whenever you sue quasi-contract, you're forfeiting your profit, of course. And so that's the next factor. How serious will the forfeiture be? In your case, it's serious. It's $250,000. And the final factor we look at, looking at it from your point of view, is did you act in good faith? Was your breach in good faith? Again, now, whether or not your breach was in good faith is just a factor. It's not controlling. It used to be controlling in a lot of jurisdictions, where if it was a willful breach, you simply could not sue for breach of contract, but that's all history. So we look at whether or not you acted in good faith, and maybe you breached when you walked away from the building. Maybe there was a strike, and the roofers couldn't be hired, and there's nothing you could do about it. It's something beyond your control. And so you may have been acting in good faith, and you might not have been acting in good faith. And so that becomes another factor. So the factors we look at then to decide whether or not you have acted in good faith, whether or not you have substantially performed, are right here. They're in restatement, the second restatement 241. And the second restatement says we look first at the extent to which the benefit of the bargain has already been received. How much of the apartment building have I already received? And the answer is, well, I've got, the building, everything but the roof, and that's quite a bit, but it's not quite everything. That's all you can do is describe it. There's no percentage, no numbers required here, and there's no rule that if you get 3 out of 5 of these or something, each one you have to just kind of look at it and evaluate and decide what to do and collectively make a decision. So the extent to which the benefit of the bargain has already been received, can money compensate for the missing performance? In the case of the garage door, yes. In the case of the roof on the apartment building, yeah. If you leave me $250,000, I can get the roof on. The extent to which the breaching party has already performed, we talked about that. You describe everything you've done already, because you're trying to show that you have substantially performed, so you'd make a lot out of all the stuff you've done. Next, the hardship. If there's a forfeiture, you lose all of your profit. And finally, did you act in good faith? And these are the factors at Restatement 241 that you would use to decide whether or not there has been substantial performance. So now let's apply that to our problem. The extent to which the apartment building has been completed, you certainly can say plenty about that. Will dollars compensate? Yes, $250,000 will compensate. You can build the roof for that. The extent to which the breacher has performed, you have a lot you can say about what you have done in the way of performance already. Hardship that you would suffer is quite substantial, $250,000. If you were acting in good faith, let's say you were when you breached the contract, then my conclusion on these facts would be that probably you have substantially performed. And you're entitled to your profit, particularly if you acted in good faith. Let's take another example. There's a famous problem, Jacob versus Young. No, it's Jacob and Youngs versus Kent. It's an old 1921 case. This is the famous case about reading pipe. And this is a case where the builder was supposed to use reading pipe throughout the structure and had used it on part of the structure, some 40% of the structure. So in the other 60% of the structure, the builder did not use reading pipe. And so the owner sued. The owner really was suing in bad faith, but that's not important in this problem. And the question was, did the contractor substantially perform in that case? Well, the extent to which the owner received the benefit of the bargain, well, the owner wanted to finish building with a particular type of pipe, got a different kind of pipe, but the pipe was basically of the same quality. So you can say a lot about the owner got basically everything they wanted. Can you compensate in dollars? Well, it's unrealistic because there's no difference in the dollar benefit that the owner received. Not much more you can say about that. The extent to which the breacher has performed, well, this person finished the building. They just got these pipes inside the wall that are a different kind of pipe. Hardship, if you call it a forfeiture, well, yes. The builder would then have to rip out all these walls and put the correct kind of pipes in. Was the builder acting in good faith? Probably yes. And the court decided in that case that the builder had substantially performed, and so the owner had to pay the contract price minus whatever damages resulted from using a different kind of pipe, and there was basically no damages for that. So in that case, you would find substantial performance. Now let me give you one more example. This was a case where you, the builder, you are building a tent on my property, a large tent, because there's going to be a big ceremonial event. And this tent is costing $50,000 to put this tent up. It's a big deal. And you're supposed to finish by June 1st. That's the deal. And in fact, the way the contract reads is I will pay you on the condition that you finish by June 1st. So now you finished June 3rd. And so you can now say a condition precedent to your duty to pay me that the event was supposed to occur. I was supposed to finish by June 1st. That's the event that's supposed to occur. And when that event occurs, I'm supposed to pay you, but that event did not occur. And it's never going to occur. So your position is you don't have to pay me because the event which I don't have to pay you because the event which was to make my duty absolute was that you present me with a finished tent on June the 1st, and you didn't, and you can't. And so you can't sue for breach of contract because you're the breaching party. So what do? You sue quasi-contract, and let's suppose this is a $50,000 project, and there is a $10,000 profit in it for you, and so you can do the whole job for $40,000. You expect a $10,000 profit. Now, on January the 2nd or 3rd, June the 3rd, you're 2 days late, you have finished the project. So you can only sue me for quasi-contract. Now, and so you're going to get your $40,000 and lose a $10,000 profit. That really, now, if we didn't have any real special reason for needing this building finished, or this tent finished on June the 1st, that seems grossly unfair. Now, if we had a powerful reason, there's a wedding on June the 2nd, and you got to have this business finished, or business building finished, or the tent finished on June 1st, or it's useless, that's different. I'm talking about the case where there really isn't any substantial reason as to why it needs to be finished on June 1st. It could have been finished anytime in early June. And so now I am forfeiting my entire $10,000 profit because I'm 3 days late and the 3 days were not particularly important to you at all. And you can see, well, gee, that doesn't seem fair. And so, again, we resort to substantial performance. And the argument is that I have substantially performed. You go through these factors. I have substantially performed, and therefore I should be paid the contract price, the $50,000 contract price, minus whatever damages that you incurred from the 2 days of late performance. So we see how that works, but we need to see how we would describe this in terms of the law of contracts. We're doing that to some extent already. But what I want to point out to you is that the way you look at this is that the society looks at these events which must occur before my duty to pay you is absolute. Society looks at these events, and I was telling you earlier how society, can scrutinize these events. They don't have to use every event that I named in the way I want them to use it, because they can produce some real unfair circumstances. And here we have one of those, because the tent was supposed to be finished on June the 1st. It was finished on June the 3rd, and now I'm going to suffer an entire $10,000 loss of my profits because I finished 2 days late and it didn't mean anything to you. Okay. Well, the public could look at that. By that I mean the court system would look at that and say, well, now wait a minute. Enforcing that, requiring the occurrence of that event that I finished on June the 1st results in a disproportionate forfeiture. That's the technical term for it, disproportionate forfeiture. I'm forfeiting my entire $10,000 profit and you get nothing out of it. That's a disproportionate forfeiture. And I can think of lots of circumstances where it's a disproportionate forfeiture. Take the case where you finished the apartment building that we were building earlier. Everything except the garage door is not painted. And so now you sue me for payment, and I say, gee, I don't have to pay because the event which is supposed to occur is you're supposed to present me with a finished apartment building. You didn't do that because the door hasn't been painted yet, so I don't have to pay. And if you paint the door, I'll find some other little thing wrong. So it'll take you a long time to get your $1 million out of me. And so you can see that letting me drag it out like that by pointing to these little picky things and not paying you, that results in also, you mean that delay. Besides that, if we call this a material breach, so you only get your $500,000, you have suffered a substantial forfeiture, and for no real benefit. If I didn't, if all I need to do is to paint the garage door, you shouldn't have to forfeit all of your profit because the garage door isn't painted. So the point I'm getting at is that when society looks at the events which must occur in order for my duty to pay you to be absolute, when society looks at those events, they will scrutinize those events and say, hey, look, now, we don't have to treat this contract. We can just refuse to enforce certain ones of those. If they're going to produce an unfair forfeiture, a disproportionate forfeiture, we can just say, no, we're not going to do that, society. And so I finished your tent 3 days late, and you want to keep my $10,000 profit, and society says, no, we're just not going to do that. And so how do you say that legally? How do you accomplish that legally? The way the society accomplishes that legally is say, look, the event which was supposed to occur in order for my duty to pay you the $50,000 for the tent was a completed tent by June 1st. And that condition didn't occur, that event didn't occur, and society says, well, here's what we're going to do. We're just going to refuse to enforce that. And requiring me to finish by June 1st or lose everything, say that will produce unreasonable forfeitures in lots of circumstances. You tell any building project, finish by a certain date or lose all of your profit. And building projects are traditionally a little bit late. And so you'd end up with an enormous number of disproportionate forfeitures if society enforced those kinds of terms. And so society simply says, or the court system simply says, that June 1st date, forget it, we're just not going to treat it. We're not going to enforce that because it produces unreasonable forfeitures. And what we'll do instead, they'll say that instead of if we're going to ignore, now be careful because society doesn't rewrite our contract. And so the courts won't rewrite the contract, but they can look at certain provisions and say, we're not going to enforce that provision because it's fraud, because there's something wrong with it. And so when you look at the requirement that I finished your tent by June 1st and there was no particular reason why June 3rd wasn't just as good, the court says, we're not going to enforce that provision. We're not going to change it. We're not going to change the date. We're just going to strike it, so we're not going to enforce it at all. We're not going to rewrite it. So when they strike the provision, then there is no provision in there that says I got to finish by June 1st. And I'm sorry, let's back up for a second. They strike the provision. They say, here's what. We will strike the provision that I finished by June 1st if I have substantially performed by June 1st. I substantially performed because I finished June 3rd, and that was substantial performance. You go through the requirements. So the court rule is that we will not require that, will not enforce the provision that I must finish by June 1st, okay, if I have substantially performed. And I have substantially performed because I finished by June 3rd, and you go through this, and I have substantially performed. So again, the courts are saying that if I have substantially performed, then they simply will not enforce the June 1st provision. And whether or not I have substantially performed is determined by these rules. And so if I have substantially performed, then on June 3rd, I get the $50,000 minus the whatever damages you incurred by the 2 days late performance. And the same thing with the apartment building. If I have substantially performed, I get the contract price minus damages. And the way that is done legally is they simply strike the provision that we've put in there. I must finish by June 1st or something. If that condition, the event that we put in there, the occurrence of that event was not really, really important, something we actually recognized and bargained for, that's specifically what we wanted, then we'll just strike it, and if I've substantially performed, then that excuses the condition, and what I have to pay you is the contract price minus damages. Now, so we understand how that works. And the situation that I want to call to your attention next is the one where the apartment house that you were building for me, where you substantially performed. Let's go back to the case where you've got, it's closer than with the roof missing. It's pretty close to what was supposed to be. But the situation this time is a little different. Situation is different because this time I'm making a movie. The reason I'm building this building is I'm making a movie. And this movie is a time period movie. And this building you're building is supposed to look like the building from that time period. We've gone to a lot of trouble to make it look just like the building from that time period, so when my cameras go off, you can't tell the difference. And so that's the way I want the building to look. Substantial performance will not do. When I have a wedding that's supposed to occur on June 2nd, and I'm saying get the tent up and operational by June 1st, substantial performance will not do. So there's some situations where we are really bargaining for that specific thing, and substantial performance really won't do because we wanted that particular thing. We bargained for that. It's a material provision of the contract. In those cases, you should get what you want. I want the apartment building to look the way it's supposed to. I want the tent finished by June 1st. In those cases, the courts will not, substantial performance will not do. You got to do exactly what the contract says. And those are the cases we say they are express conditions, is what we call them. They're express conditions. We expressed the event which must occur, and we really, really mean that event must occur because of that occurrence of that event was a substantial, a material part of the bargain, and we knew it from the beginning. And it doesn't produce disproportionate forfeitures because the person who is bargaining for the apartment building, you're bargaining to build a building, you understand from the beginning that you've got to do exactly what these plans said for the reason I mentioned. You're building the tent, you understand you've got to finish by June 1st because of those reasons. So you bargain. So we're not causing a disproportionate forfeiture because people understood from the beginning and bargained accordingly. So that's what the doctrine of substantial performance is about. There's a case that was tested on the bar exam where a house was to be painted by September the 1st. And the painter ran into a lot of problems with bad weather and stuff and did not finish until September the 20th. And the owner then was in the position of saying, well, you didn't finish by September the 1st. The event which is supposed to occur to make my duty to pay you absolute did not occur. I don't have to pay. You can sue quasi-contract. And in that case, the painter would lose all of the painter's profit. And so the question really is, did the painter substantially perform? The painter was 20 days late, and you had to go through the factors and decide whether or not the painter had substantially performed. There was a case of a lawyer who was writing an appellate brief for someone and got basically all the work done and got down to the point there was some minor adjustment or something they wanted to make. And at that point, this lawyer got appointed as a judge. And the lawyer was doing this on a contract basis for some other law firm, was doing the appeals for a law firm. But when they had gotten to the point where any other lawyer could have sort of done the final step, this lawyer was appointed as a judge. And the question was, does the law firm that's paying this contract lawyer, do they pay the contract price minus the damages, or do they pay quasi-contract? And the same thing. I think on those facts you'd find that the lawyer who prepared the appellate brief had substantially performed, used these factors. Now, there's one more thing I want to point out, and that is that the contracts we've been talking about are common law contracts. We're building houses. That's where these issues most commonly come up. But we're building houses, we're painting houses, lawyers are doing work, and we're putting plumbing in and that kind of stuff. All common law contracts. Well, in UCC contracts, where we're talking about the sale of goods, well, you also can have the same situation where I did most of what I was supposed to do, but not quite everything. And what do you do in those cases? Let's talk about those because those are our final cases. In those cases where it's about the sale of goods rather than if it's common law, then we would use the substantial performance doctrine. We've been talking about that doctrine, so you know what to do there. But if the contract is not a common law contract but a UCC contract, what do we do when a person does almost everything they're supposed to do but not quite everything? And that's covered at UCC 2-601, and it is the perfect tender rule. The UCC says basically to forget about all this stuff about substantial performance and so forth. You either do it or you don't. You deliver the goods that you said you were going to deliver, the correct goods at the correct time at the correct place, otherwise it's a breach, and that's all there is to it. And this is done because you can understand how if people are in business selling goods and they need the goods there at a certain time, that's a different sort of thing than the common law transactions. And so the UCC just made it very simple. Do perfect tender rule, period. Trouble is that the perfect tender rule has got some exceptions. And the exceptions that matter are found in three places. 2-508 subsection 1, 2-508 subsection 2, and 2-612. 2-508 subsection 1 says, here's an exception to the perfect tender rule. And the exception is, if I shipped the goods to you and they got there early before time for performance, and now I find out it's the wrong goods, it's non-conforming goods, normally that's a breach at the moment that you get them. It's a breach right then. But we make an exception, says, well, you got them and it would normally be a breach, but if I find out about it and I can send you the right stuff and you get it in time before time for my performance, then that's not going to be a breach. And that makes sense. So this is the case, 2-501, is where I cured before time for performance. Secondly, 2-508 subsection 2. Now this is the case where when I sent you the goods that you asked for, I thought that, I didn't have the goods you wanted, but I had some sensible reason for believing that you would accept these substitutes. And when you received them, you said, no, I don't want these substitutes. No, I thought you'd be okay. And so, but in that case, again, the minute you get the wrong goods, technically that's a breach, but we excuse that breach by saying, if I can correct it in time, you got the wrong stuff, but if I can send you the right stuff before time for performance is over, that's another exception to the perfect tender rule. And finally, 2-612 says, in these installment contracts, now this is important. In an installment contract, let's say I'm supposed to do stuff for you 10 times. I'm delivering widgets to you for 10 months in a row on the first day of every month. And that's my installment contract. I deliver, you pay, I deliver, you pay, I deliver, you pay. Now, in the installment contract, let's suppose on the 7th installment, my delivery was 1 day late, or I had something else was slightly wrong. Well, under the perfect tender rule, if I have, that's a breach, the minute you get this wrong stuff, and it would be a breach of the entire contract, the entire 10-month contract, because the 7th delivery was 1 day late. And the court's saying, well, I'm not sure we want to do that. And 2-612 says that's not a good idea. What we're going to do is the following. If my 7th payment, 7th delivery, is defective in some way, and that would be a breach, that we're not going to let that be a breach of the entire 10-month contract unless, number one, the rule is that if the breach can be cured, and if I give you some assurances that I will cure it, and the breach does not impair the entire contract for some reason. Now, the breach on the 7th installment didn't ruin the entire contract, which generally is unlikely. Okay, then that's not going to be treated like a breach of the entire contract in these installment contracts. Otherwise, you could wipe out the entire installment contract with one a little bit defective installment. You said, no, we're not going to do that unless this little bit of installment ruins the entire contract, substantially impairs the entire contract, and I refuse to cure it, or it can't be cured. Now, if I performed a day late, and let's suppose that the day late didn't really matter to you, so it didn't ruin the entire contract, you say, well, yeah, but that cannot be cured because if I delivered a day late, I can't go back and deliver a day early. Time's already passed. So how can I cure that? And the answer is that, well, if it didn't matter that much to you, just pay you a little bit of damages for performing late, or just excuse it. If it really didn't matter that much to you, I promise you that I will not do this anymore. The rest of it will be on time from now on, or something of that sort, where you've got a little bit of late performance and it can't be undone. My assurance that it will be done properly in the future would probably be sufficient. So when we have a UCC rather than the common law, the rule is perfect tender. These are exceptions to the perfect tender rule. First exception is that I can cure it in time. The other one is I thought the stuff I was sending to you was okay. It wasn't. I can still cure it in time. And 612 is the installment contracts. Now, that's what substantial performance is all about. I think that you are so well informed about substantial performance at this point. But let's go through it quickly. You understand that when there has been the reason people want substantial performance as opposed to a total breach because they're going to lose their profits if they don't. How do you decide if there has been substantial performance? Go through these factors, and say something about each of the factors and reach a conclusion. And don't forget that if there might have been substantial performance and there might not have, when you go through these factors, you should go both ways at the end of your analysis. That if there was substantial performance, here's the results. If this was a material breach, here's the results. And that is the end of the lecture on substantial performance. I really think that you understand the material well. Understanding it is important. Of course, we talk about in terms of conditions occurring rather than the event occurring, but it's better to understand it in terms of the event occurring and how you substantially, you cause the event to substantially occur, not perfectly. The apartment building isn't perfectly presented, but it is substantially present, and that's sufficient to excuse the condition, and you pay contract price minus the damages. That's the end of this lecture. I really think you know the material well, and good luck.